So, if we're dealing with a discretionary trust, the first question we need to ask is, who is the beneficiary? Is our client in fact a beneficiary of that trust that we're dealing with, or is their spouse a beneficiary? This is a critical question that comes back to that first point. We need to read the deed to understand who are the beneficiaries and what are their rights. Fortunately, there's a fair bit of guidance we can find around this. Aside from the fact that we need to read the deed, including any sorts of deeds of variation, there are some common tricks and common issues that we should be keeping an eye out for. The first one is identified in a case by the name of Yazbek, and this, although it is a tax case, outlines the approach that the courts take when they look at who beneficiaries are. And Yazbek is significant because the court has confirmed that a person who is eligible to receive something from a trust is a beneficiary, notwithstanding that they may not have actually received anything from the trust. Yazbek was a decision in the context of an assessment which had been issued to an individual beneficiary, and the ATO would normally have had a 2-year period after that assessment was issued in which to issue a new assessment, a reassessment, on the basis that they'd identified some additional tax that they thought the taxpayer should be liable for. So they normally had a 2-year window of time in which they could issue an amended assessment to the taxpayer, and after that 2-year window is shut, that ability to issue it would disappear. But that standard 2-year window is extended to 4 years, where the individual involved is the beneficiary of a trust. And the tax year in question that the ATO was arguing over was around 3 years after the original assessment had been issued. So they're outside the 2-year window, but within the 4-year window. And importantly, the taxpayer here hadn't received any distributions from this discretionary trust that the ATO contended he was a beneficiary of. This was a discretionary trust which was controlled by other family members, and he was included in a wide class of discretionary beneficiaries, but had not actually received anything. And his contention was that in order to be a beneficiary of a trust, he needed to have actually received something from it. Now, the court was quite quick to shut that argument down and said that even if a person has not received any income or capital from a trust for the entire period it has existed, if they're within a class of persons who are eligible to receive something at the trustee's discretion, they are still a beneficiary of the trust.